It's my pleasure to introduce Shannon Freeman and Maya Brown. They are from DCYF headquarters, and they are here to talk to us about the ICPC process. So with that, Shannon and Maya, it's all yours.
Well, thank you. Thank you for having us. We'll start really quick with just introductions, and then we'll get right into it. We know it's a Thursday afternoon, so we know what that's like. I am Maya Brown, and I'm the compact administrator for ICPC and also ICMA. Shannon.
I am Shannon Freeman, and I'm the deputy compact administrator for ICPC.
So today, we are going to talk about the overview of the ICPC process, why it's needed, when it's needed, special circumstances, responsibilities, timeframes, violations, and the impact of violations, and then have time for questions. Why we have ICPC. So it's the only way we have to know what's happening in the other state. We like to say that the other folks in the receiving state are our eyes and our ears, and really help us determine if the other placement is safe. So that's the premise of it. ICPC has been around for a long time, since 1971. So a lot of other states were 20 years or so in before Washington actually enacted the Interstate Compact. It originally started in the Northeast, New York, New Jersey, those states where the borders blend very easily. And it was really difficult to get services and supports for children when they were placed into another state. Currently, all states are a party to the compact, as well as District of Columbia and Virgin Islands. Puerto Rico is not part of the compact, but they do try to assist if we have a family there that were to be assessed for placement. So they do assist. ICPC is a little bit different, that it's a uniform legislation is how states enact it. So in the language of each party state, we all have a law or RCW in Washington that the language is exactly the same. And one of the challenges with ICPC is that it is, as you saw, is over 50 years old now, but it was enacted many years ago, and now to get all states to agree to something new and different, very challenging. Hasn't happened. So it is one of the challenges we have, is that, you know, it was written a long time ago, and to get folks to agree and to change the process can be challenging. So, but really the bottom line purpose for ICPC is its job is to try to ensure placements are safe, and it fixes responsibility. The sending state is responsible for doing certain tasks, and the receiving state is responsible for doing certain tasks. When is ICPC required? We'll talk about parents in just a second. We have a little asterisk there because we get a lot of questions about parents and ICPC. But generally speaking, all of the placements on parent, relative, foster, adopt, group home, or residential and adoptive are covered. And then there's situations mainly related to education or medical type of placements are not covered under ICPC. So if a child needs to go to a different state for treatment in a medical facility, ICPC is not required for that, as well as if they go to a school or join the military, Job Corps, ICPC is not needed for that. So some of the information on the parent slide is there just for that information. I'm not going to go tightly over the law. What am going to talk about is that the regulation of ICPC and our policy require that ICPC applies to parents when there is a dependency to that parent. So that's kind of the piece to be aware of. I've included the language. There was a Court of Appeals decision around that, and that's where that came from. Before, ICPC applied to all parents. Regardless, you could seek information through ICPC. This Court of Appeals decision required that a parent be found unfit for ICPC to apply. So I'm not going to necessarily read the slide, but we have another one too that provides a little bit more information that speaks to that. So I just wanted to include it so it's there for you to have. I'm sure there'll be questions about that. We can take those at the end. We're happy to. We just want to make sure we at least get through the slides initially, and then we'll open it up. So big piece here is that the placement is unfit. So the ICPC is a 2 steps for approval. So we have times where someone says, run out and get a home study in the other state, and then we can just place there through ICPC. With ICPC, there's 2 pieces to that. You've got to have a placement evaluation that's child specific prior to placement, and ICPC approval if you want all the things that go along with ICPC, which is those assignment of those responsibilities. So supervision, medical, so that the family can access supports in the other state, that comes with ICPC approval versus if there's not, placement occur, but the other state has no responsibility to provide those services to us. And the placement must be in the child's best interest. I know that sounds like, well, of course, we wouldn't place without. I think that what happens sometimes is when we place children, or where that comes into play in our world, is we place a child, there's a big rush to get a child to the other state. The child gets there, maybe there's not appropriate services or supports for that child. What will happen is the other state can inform us that we need to bring that child back to Washington because those services are not there for the child. We're not providing those services. So that's a big piece, is that anytime during a placement, there can be a determination that the placement is no longer in the child's best interest. So we've got to make sure that we continue to support the placement and make sure the services are in place for that specific child. So I mentioned that the original ICPC 1950s, there was now a Safe and Timely Act for children in 2006. Those are kind of the 2 big legal things for ICPC. And what this act did was it established that the home environment is reviewed in the other state per that state, right? So Michigan's going to do a home study according to Michigan's rules. Washington does a home study if we're accepting a child based on Washington's rules as far as the home study. And it establishes where we know this is that ICPC can take a long time. And one of the challenges is not hearing back. So it established that the sending state should be provided with a report. If the home study cannot be completed by the end of 60 days, that we should get a report about what's outstanding, what is still needed to complete the home study. It is not a decision to place. It's not a decision either way. It's just a status report, a preliminary report of how things are going. And it also establishes that a final placement decision should be given at the 180th day. Additional timeframes we just thought would be helpful in the work you do, just to remember that some of the timeframes we work with are home-based placements, relative, foster, adopt, parent, that approval is valid for six months for the placement to happen. So it doesn't mean if the child is placed after you get approval, let's say 30 days after you get approval, that at 6 months it expires. It's just you need to make placement within that 6 months, or we've got to ask for an update from the other state. We've got to meet that deadline, and that is based on the date that the 100A form is signed. When we do facility-based placements, so Northwest Children's Home is the unfortunately, I don't mean to be popular, but a frequent one is a better word, I should say. 30 days for facility-based treatment. If we get an approval, we've got to make placement within that 30 days. Child can remain there longer. It's just that initial placement. Another time frame that ICPC works under is 5 days return. So if a placement disruption happens, the other state asks us to remove the child, bring the child back to Washington, we have 5 business days to do that. This quickly outlines the responsibility of each state. I think, not just to read off the slide, I think the important pieces is for our all of them are important, but the main things that I think that can get swapped, or what Washington does, what the other state does, is kind of those financial obligations. So Washington's responsible for foster care payments. Washington's responsible, or I should say states are responsible for childcare per their policy. So that's a unique thing about Washington. I think there's probably a handful of states left that pay for childcare, and Washington is one of them. Oregon does not pay for childcare. Idaho does not pay for childcare. So it's definitely, it's just, at least there's that piece is there, because I know it's definitely a struggle for states who don't pay for childcare. So we do that. If the child's placed in another state, they find a licensed caregiver, child caregiver. If they're eligible for that here in Washington, we would pay that in the other state. When we say counseling and services, I want to indicate that is above and beyond the medical card. So that's something to keep in mind, is that through ICPC, the child may receive a medical coupon in that state, but if the child's needs are higher than that, or they need additional supports, or there's some type of specialized therapy that card doesn't cover, Washington, the sending state, remains responsible for that. So that would have to be contracted for, paid for somehow. All those things fall on the state that has jurisdiction. The other state assists us in maybe finding providers, can say, hey, this is where we do occupational therapy in our community. But Washington would have to follow up with that if it's beyond what is covered by the medical coupon. As far as I was just going to say one more thing about the receiving state. Their initial task is to assess if the caregiver has the ability to meet the child's needs. That's part of that home study. That's child specific. That's a big one, because sometimes that can be an issue where a child has specific needs and the caregiver may be able to meet specific needs of a child, but it's this specific child we're sending that they've got to be able to meet. And the community as well, that's another piece that the receiving state knows their community. So if the child comes with a list of services that need to be provided, if their community doesn't provide that, sometimes we get an ICPC denial based on what the community has. And then they also provide us with courtesy supervision, and which is we get reports quarterly. They see the child monthly, we get reports quarterly. So a couple of special circumstances. Pretend the slide only has half the words on here. We apologize, but we just try to get it in. And we also know that it's a resource for down the road. So it's important to, and that's the other piece that I also kind of want to put out there, is that not every single piece is covered on this. These are things that we staff every time these come up. So that's another piece, is that we've highlighted the important pieces, but there's much more to the law or this part of the regulations that we use within ICPC, but we just wanted to highlight to give information about some of the things that ICPC has added in over the years, regulations that help us, some of the real life things that happen in lives that we can try to support, and is not as much of a challenge as just, hey, we need, this child can't go with this caregiver even though they've been with them. So these regulations can help with some of that. We want to just touch on the highlights. Again, this is not every piece of this. So Regulation 1 is really great when it works. This allows, it's easier for me to give an example of, you have a foster parent here in Washington. The child has been with that caregiver for 8 months, 9 months. Their home study is done. Oh, I got to transfer with my job. I'm moving to, what's a state I haven't used for a while? I'm moving to North Dakota. Regulation 1 allows us to request an ICPC and allow the child to move with the foster family while the other state does their home study, and the other state provides courtesy supervision. Okay, so basically it allows, the other state gives kind of credit to our home study until they can complete their own, and they have to pass that. We can only work a couple of things. The child has to be stable, and the family has to be stable, and they have to be there for at least 6 months, because the other state may ask it. Part of the regulation is we have to provide 6 months of the courtesy supervision or health and safety reports to the other state. We usually can only ask for the same type of home study. So if they're foster licensed here, we can ask North Dakota to do foster care. We always push for the permanent plan if possible, but as states, as we'll get more into that, states don't allow us to do adoption home studies sometimes until the children are legally free. So that can be an issue, but generally speaking, you can get the same type of home study that the child was in here in Washington. We say that it's not for every family and it's not for every child. And part of that is there's no foster care payment, right? Once they leave their home in Washington, they're considered unlicensed. So they are not fully licensed until they complete their home study in the other state. And for some families, they need that financial support. So that may be a situation where it's not for every family, every family. We don't have another way to support them until they're back in an approved placement or licensed. Also, if their child has specific medical needs, there are some states who don't start, or we can't initiate the medical until the home is fully approved. There are other states that can turn medical on. They'll do it at the time the child comes, but it's very few. We assume that there's no medical until the home is fully licensed or approved in that state. So again, it's not for every family and it's not necessarily for every child, but it is an option if there's a stable placement, they just haven't established permanency, and they've got to move. That's generally where we see regulation 1s. It's not, a lot of people try to fit regulation 1 as, oh, let's have the caregiver fly to Washington, rent an apartment for 3 months, rush into a home study. I don't have 6 months worth of supervision to provide the other state. So like, there's just certain things that don't fit, right? Like, so that's, we see that where people try to squeeze that in as the regulation, but it doesn't meet their criteria. Also, you know, if the placement is unstable, it's not a situation. What will happen is if we send the family, the other state goes out to start their home study, and the family, and if the child, if they're at, you know, Delta level 5, I need help, I need these supports, I can't do it, the child's, I don't know the behaviors. The other state at any time, that's an assessment period for them. They'll ask the child to return until they complete their home study. So it has to, like, again, it has to be one of those placements that's secure, stable. They can manage for several months without a ton of support. They'll have a courtesy worker coming out monitoring for health and safety, but without all those medical foster care payment, it may not be where they get connected to every service right at the initial onset of placement. Or I should say the study, when they very first get out there. So that's an option that's available for families and children who might be able to fit into that, you know, the criteria of the regulation. We also have regulation 7, which is for specific case circumstances. A lot of times we hear, oh my gosh, let's expedite it, order a reg 7, right? I've heard of something, let's order it. It's only to meet the criteria of an expedited home study. There's certain legal criteria. It's a court order that's drafted. The worker has to have the study, the request ready to go, typically. So the criteria is listed here. There's, you know, unexpected dependency due to incarceration, and you can read down those. The child is age 4 or younger. Child is a sibling group. Emergency placement, and those are pretty emergent. So it's all of our placements can be considered emergent placements, but they're going to look for what exactly, you know, is emergent about that specific thing. So a death of a parent, some of those things are, you know, it has to be a unusual kind of circumstance. Requires, again, a specific court order, not just the court saying we're doing a reg 7. And the other piece that I have to say is that not all states accept reg 7s. As much as we like to think, hey, we can do this, Washington is in that boat. We can't complete background checks in the amount of time that typically required. We do other things to try to expedite. We try to honor that, but we immediately let other states know. Not all states do this, but we immediately let other states know so they can inform their court that, hey, we don't usually meet reg 7 requests. We will do our best and we'll provide a report at the end of that time that it's supposed to be 30 days. And reg 7s only apply to parent and relatives, right? It's not for some states that require foster care licensing. They don't do reg 7s. So there's a little more that goes into a true reg 7. The other piece that can happen that I just like to call out is that sometimes what you get back from a reg 7 is not enough information for you to safely make a decision if the placement is safe or not. So for example, we can't meet background checks a lot of times, but so another state may provide us a reg 7 that says, hey, pending background checks, here's approval. right? And that's going to be hard to fly, at least in most courts, if we don't have a background check, at least on folks. So sometimes, so those are things to consider when requesting a Reg 7. Trying to think of anything else about Reg 7s. Shannon?
The placement resource can only be a parent, adult sibling, aunt, uncle, or grandparent. It can't be the greats or a cousin or
Yes.
anybody out of that placement category. But like Maya said, we usually staff these type of special circumstances because they aren't for every case and every scenario. So these are cases that workers generally call our office and staff with us, not just submit a request to us, because there's other things to consider when we're requesting these types of ICPC homestay requests.
Yeah. And it's also a lot of time is spent or people are, you're anxious and you're trying to get this to go through. Well, if the other state doesn't even accept them, it's helpful to know that beforehand, right? Before we go through this whole process. So that's another piece that when we're training our staff in the field, if someone wants to do one, call us as soon as possible so we can maybe reach out to the other state and find out if it's worth everyone's effort and the court being involved, that we're doing this. And it's like, oh, it's a state that doesn't even do it. And that's another piece is that these are regulations. The part of ICPC that is the law, those are articles. So regulations are pieces of that have been built in or we have added that states can do to try to assist in these kind of real life things. After this 1950, this was developed. Well, hey, now we have families that transfer, and now we have situations where someone is incarcerated or there's a death and we really don't have anyone else in the state. We're at a high level, that's when a Reg 7 comes into play, not just like, well, we know they have background, there's criminal history, but we're going to go ahead and send a Reg 7. The other state is likely going to say, hey, we need more time to assess this. This isn't one that we feel is, we can give you a good determination in 30 days. So those are things to think about too, is that it's just not, not every state can meet them, but also, is it really what is going to be helpful for this child and this family?
A quick question. Is the Reg 7 new? Like as a DGAL staff, I hadn't heard about that before. I mean, it's probably just a department thing, but is that something that's newer or?
Well, it's a great question. What it is that a lot of states can't meet that time frame with all the backlog, with the requirements of background checks, as well as just staffing levels. So it's not something, I would say we probably do less than 5 a year.
Okay, that makes sense.
Right? Because again, it has to meet these certain criteria. It's got their, and I'll point out, right, for you see parents on here, but with Washington, the way that parent is, and the tight frame of what a relative is, again, it just is, it's a very narrow scope, and the intent is that if, that this should be our most emergent case, emergent cases that states stop and hopefully this person is a good, we can use this for this child. But sometimes it's not used that, like I said, there's some states that send a lot of Reg 7s, but it's not the intent of that. I think that it was meant to be. Of course, we try to honor the, again, Washington, we at least say, hey, we can't meet it, but we're going to work as quickly as we can to, and at least provide you with an update. But I think we just got a Reg 7 the other day and there's criminal history. And it's like, we can't, that type of an assessment usually takes a little bit longer, or we're going to have to do some research. We're going to have more information than we can do in this short amount of time. Or 3 kids into a 1-bedroom, like it's not, the caregiver's not set up, but we're going to try to see what we can do to help. But those are some of the things that happen with Reg 7s when it's not necessarily kind of thought all the way through, or we really talk to the caregiver to say, hey, if these kids could be there in 30 days, what does that look like in your life? You know, if we send a worker out there in 15 days, is this an appropriate situation for kiddos? It's not saying that in 2 months they couldn't be ready, but sometimes it's just not always that follow through, or folks are really anxious to order it, but we aren't thinking about, you know, a worker's going to go out there and really be thinking about these kids will be here in a very short amount of time, and is the caregiver really ready? Or if there's any type of history that's of concern, usually the state's going to want more time to assess that. So we don't see a lot of them.
Thank you. And is there anything that the DGAL could do, or the guardian ad litem could do to help? Or I assume that the state would know if they are able to do to do what they can do to speed things up. But is there anything that the guardian ad litem could do to help?
I think that, you know, if you're aware of a case that is, you know, on this extreme end of circumstances, I think help. I don't know if there's something specific, but I mean, it could always be like, hey, could you check with your ICPC office to see if we could do a Reg 7 on this? Is this one that would meet that criteria? If it comes, you know, if it is in this kind of end of something really kind of extreme has happened, or that it's a relative and it's a very close relation, you know, so, you know, just knowing a little bit about the type of case and then just paying attention, maybe if a worker's overwhelmed or new and doesn't know, to suggest, you know, checking with your ICPC office to see if this would meet that criteria. Or sometimes the AG's office checks into, just depends who's asking or what's needed. So I think that's it, just because the turnover in staff, you know, is, I don't know if where everybody is located, but if I feel like it, I think it's across the whole, you know, we just have a lot of, okay, I see Ryan shaking his head. We have a lot of turnover in staff. So sometimes even if we say this to them at their training, it's, you know, just they hear that we don't do them incoming, you know, for kid that they may not put 2 and 2 together. So I just think knowing that maybe, hey, this might be an option, and then having them check with our office is a great, I think something great that would be helpful.
Well, thank you. That is like, this whole training is worth just that, knowing that there is such thing. I hadn't heard of Reg 7 before. So thank you.
Yeah. Or Reg 1 is really great if it works well. Like if you do have those families that are just stable, and for whatever reason, we've seen a lot with COVID and maybe military families where they just couldn't get the adoption to finalize, and now this person has to move out of state, they get to take the kids with them. We get supervision, everybody's happy, you know, like the department, everyone's, it's great. And then, yep, it does delay things because the other state has to complete their assessment, but these kids don't know a difference, right? They're just moving with their family. And it goes very smoothly. The ones that are challenging is when we try to force, or it's not a stable placement. It's the same thing our workers do here. If you go out and they're like, whoa, I just went out to collect paperwork and the family's in crisis. And they've just been here 30 days. Those are the ones that are really hard, just, you know, upsetting, hard for me, because I understand the intent, but we also know that all of the transition for our kids, they deal with some kids just can't handle it. And so we just have to be mindful of that too. So I'm going to let Shannon talk for a little bit.
Thank you. That was super helpful.
Yeah, no problem. And we'll have questions at the end. So please, if you have questions, jot them down, and we'll also, you know, as other folks think of things. Take it away, Shannon.
All right, we have a border agreement with Oregon. States are allowed to do certain border agreements between themselves. It takes a lot of work, and we actually started this border agreement, gosh, I think 10 years ago, and now we're considered what's fully live around both the borders of Washington and Oregon. So what a border agreement is, it will allow a quick placement into a border county if the case originates along a border county. So I have those blue border counties highlighted. So it has to, the placement in the other state has to be a relative or someone with an established substantial relationship with the child. The family can't live outside of Washington or Oregon for more than 3 years. And similar to the regulation 1, we can't pay foster payment until the home in Oregon's fully licensed. So when Maya was talking about how these special circumstances aren't for every case, this is kind of one of those scenarios. It has to be, there's a lot of criteria that our workers look at when they are staffing these border agreement cases. There's things that get started really quickly. The family has to be ready. It's kind of based on our state's emergent placement criteria. So that's kind of the reason for not living outside of the states for more than 3 years, so that we can do background checks and get that information completed. If a family has certain criminal history that can't be waived in that time frame, it wouldn't be inappropriate for a border agreement. But these cases can be also really helpful to get children placed with relatives or families along border. These border counties really quickly. A lot of these counties share services, so sometimes children can continue to go to certain services. We've had a lot of permanency out of some of these border cases, and it's been a pretty positive thing for these cases. So that's really exciting. Visits are covered under the Regulation 9. So I'm going to talk a little bit about what visits are and what how the visit is not considered, how it can be considered a violation of the interstate compact. So when we talk about a true visit, we're talking about the child's going to a visit to relatives. There's a begin and an end date, and they're coming back. The visit's not extendable. The court doesn't order an extended visit. You can't stay there longer. It's that true social experience. They're going on a visit. We need to remember that there's no supervision and no supports when children go on a visit. It's less than 30 days or the natural school break. Sometimes that gets tricky when we think about a whole summertime, because we can't meet our requirements of completing health and safeties, and children need to be in therapy, those things. So a lot of times that piece doesn't work out. The piece of the compact is we haven't already submitted an ICPC request. So states consider, if we've submitted an ICPC request and the home stays in process, if we then send a child on a visit, it can be considered a placement and a violation of the compact. So a lot of this came into about they don't want, it's hard to assess somebody. It's hard for relatives to go to training. It's hard to get all of this home study pieces done when there's children there on visits, taking up some of that time. We've also had a lot of situations where proposed placement resources get burned out because children have been sent on a visit and then the court extends that visit. We can't get any of those services that come with the interstate compact without that home study and ICPC approval. A little bit about illegal placements, and we took this directly from the compact, and I'm not going to read the slide, you guys can read that, but it does talk about how illegal placements, and a visit would fall under that, or placing a child without ICPC approval, that it would be a violation of the law in both states. So there's things that can come with that, and I think I have that on the next slide, so I'm going to pop over there. So some of the illegal placement, placing a child in another state without our approval, it gets challenging because our children deserve to be placed in a placement that they can have the resources and the support they deserve, right? Like these are Washington children. We want to be sure that they have the supervision, the medical coverage, they can get enrolled at school. Somebody in that state is doing that supervision, and without ICPC approval, we don't have that. It's important to remember, just because the other state doesn't tell us we have to return the child, or they don't say anything about the child being there, it doesn't mean things are going okay. That other state worker, if they're doing a home study, isn't looking at that child or that stability, because that's not their role. They're there doing a home study. It can affect future requests to that state, and it can affect the home study we may have on that child going to that state, because they're thinking, oh, somebody in Washington said it's okay to violate the compact, but here I have Idaho following the rules and not placing their child. I'm going to go ahead and prioritize this home study of somebody that's waiting. So we don't want to delay that child, the home study for permanency for that child. We've had several cases last couple of years that placements like this have led to disruption, caregiver burnout without supports and services for the child when children can't get into therapy, can't get medication, can't get those things. So it's not a great situation for all those. Receiving states who discover children are placed, they can do a couple different things. They could remove the child and place them in foster care if something happened in that state or that family wasn't appropriate. They could request we return that child to our state while they complete their home study. They can also file complaints against whoever was involved in that scenario. So they can file complaints against state bars. If there's private agencies or entities, they can file those cases. And we have a national ICPC office, so they can also contact the national AICPC office for mediation. I know sometimes we have heard about scenarios like that. And it's important to remember whoever is involved in sending that child to the other state assumes all liability for these illegal placements. So something terrible, unfortunate happens to that child while they're placed in the other state, then of course we're liable for it, but it's also not always in the best interest of the child, right? Like we think that relatives may be able to pass a home study in another state, but something happens or they don't have the support and something happens, and then the child ends up coming back potentially injured, or with that letdown that placement didn't work out, and then they've really had that other connection lost. The home study we talked about, Maya talked about in one of her slides, it's completed per the receiving state standard. So some states require all relatives to be licensed. So they would get a foster license in that other state. I think it's about 30 states now require most relatives to be licensed. So that's beneficial for states that we can then reimburse families that foster care reimbursement. So that's helpful. They may not accept an adoption home study before TPR. I can tell you most states won't accept an adoption home stay before TPR. So we either need to send it as a relative request or foster request. And then the home stay should be child specific. It should address the child's needs and behaviors, what skills the caregiver has to assist that child, and what services might be available in that community. There are some home studies that other states will do that come with conditional approvals. It might be furniture needed. It might be somebody moving out of the home. It might be a class the family needs to take. All of those things, if the home stay comes with a conditional approval, is Washington's responsibility to make sure that those things are done before we place the child. And a lot of times we need to let the other state know that those things were done and now we're looking at placing our child. Denied home studies, important to review the denied home study. If there's reasons that a home stay could be corrected, it might be denied just because the family didn't respond timely, or it might be denied because the family didn't have space, but now they've moved to a larger home. Some of those could be resubmitted if the reasons for denial weren't a permanent denying situation. So after the home study, when the workers reviewed it, they've staffed it with their team, they've made a decision, yes, this is the place that we want to place the child. They've met all the conditions, they're making their transition, whatever that transition might look like. Important to send the child with appropriate medication and clothing. there's nothing worse than coming in on a Monday morning and getting a phone call from Colorado that Washington sent a child without a coat in December. I can tell you that hearing that phone call over the wall when Maya and I were in the office, I was just some of the things, like we really have to be planful when placing these children to be sure that they have all of the things that they need for that certain community. The caseworker in Washington is responsible for getting the 100B form to us within 5 days of placement. That form is the placement form that tells the other state the child is placed, please start supervision and services. The other state has 30 days to do that from the date that they get the form. So it's really important that our workers are sending the children with the appropriate medication, that they've done a health and safety within a couple days of the child leaving, because a lot of times, that case takes a little bit of time to get assigned out depending on the state or county the family lives in. And then the caseworker should be coordinating with that ongoing courtesy supervision worker, providing information and consulting with them to ensure the child's needs are met. If there's services that the child needs that isn't covered by the medical, then we need to figure out how to contract in that state and get those additional things for that child. Permanency across state lines. We do achieve a lot of permanency in ICPC. So we like to really celebrate those. We sometimes send each other emails now that we're teleworking, because our unit does a lot with paper. So we like to remember that there's children behind these scenarios. The permanency happens after a period of stable supervision. It's generally a minimum of 6 months. And what's required, the law calls it concurrence. It's the written agreement from the receiving state office to complete our permanent plan. That can be the dismissal of dependency to a parent, transfer of custody through guardianship or adoption, just however we're going to achieve permanency, because it's our plan in the other state. We need that receiving state's office. They're usually looking at that the placement's stable, the family has what they need, the child has what they need, and they're okay for us to go ahead and complete that permanent plan. Some of the challenges with ICPC, people are unfamiliar with the ICPC process, and that's really normal. Not a lot of cases are ICPC. We do this every day, but for workers, they might do 2 in their time as a worker. State laws vary. Some, like we talked about, the states will accept adoption before TPR or not adoption for TPR, or people have to be licensed. And of course, that varies just like our own state with our own policies. Financial and medical can be tricky. How financial and medical, how the law is written is if a child is 40 eligible and placed in a licensed home, they will get medical. In other scenarios, the medical isn't guaranteed in that other state, but that's when Washington becomes responsible for that. So that kind of weighs into it. ICPC can be very technical. There's a lot of steps to it. This is why some of those special circumstances, we ask workers to call us and staff those cases, the border agreement, the Reg 1, the Reg 7, just because we want to check with the other state if certain things are allowable or not allowable. Timeframes, I think a lot of times people have unrealistic expectations. You hear the safe and timely requires that 60 days. The 60 days means that if the home study isn't done, we're getting that status update. We have to remember how long it takes Washington to complete home studies for our own children. The difference is you might not realize how long that home stay is taking because a child can already be placed. In our own state, we can do the services, the child gets medical, but when we're placing a child across state lines, ICPC is how those safety things happen for that child. We always like to tell workers, plan ahead and start early. There's nothing that says you can't submit ICPC within a first couple months of a case, or if parents aren't progressing or doing well, because that home stay is going to be valid for 6 months. So we know ICPC, we know home studies take a long time. It's not ICPC that takes a long time, it's the home study that takes a long time. So plan ahead and start early. You always have that You know, even if there's a relative here the child's placed with, there might be a relative in another state that wants to be assessed, then you'll have that 6 months if something, if a disruption happens here and the child might have to move if something happens in somebody's lives. Important to communicate with all parties. It's a good recommendation for workers once they submit an ICPC request, call the family in the other state. And if the family hasn't been contacted within 3 weeks, to let our office know. Sometimes we want to make sure that all the paperwork got there, especially with people teleworking, or that we've sent out the request. We haven't needed additional information from them. Maintaining contact with that family throughout the life of the case. It doesn't mean that the other state workers doing all of their work for them. They're only providing the courtesy supervision. So it's important to keep the family updated with what's happening in court, what's happening with the case, making sure that they're getting what they need, or if there's a way that we can assist. Don't make assumptions. You know, there's things that we can try to staff, brainstorm, those kind of things. And of course, contacting headquarters ICPC staff with questions. We put a slide just with how we break out cases. We have 4 social worker specialists in our unit, and we assign the cases by oldest child's last name. So that information is on there, and Maya and I contact information is on there also. So I think we have time for questions, and we said we would follow up with questions when we're done. I think there was a question in the chat, but it looks like Maya answered it. Somebody had asked, can you confirm dependencies needed before starting ICPC? And the answer is yes, dependencies needed before we can submit ICPC.
Now, is that for both parents or just one?
Just the
Have
parent.
dependency on both?
Just if you're requesting a parent ICPC, it would be for the parent that's out of state. If you're requesting on a relative, foster, adoption home, you know, another type of ICPC, you know, home study, you only need dependency on one.
Okay.
Doesn't matter. One other thing I wanted to add to Shannon's that came to me during the hearing about relative burnout, or asking, just send the kid on a visit, nothing's ever happened before, we'll just do that, is that a placement emergency in Washington, as we've learned through some of the court and things that have happened with certain specific cases where children have been on visits and things have happened and torts. A placement emergency in Washington does not mean a caregiver out of state is a safe placement. It sounds like it on the phone, they sound great, looks great, all these things are great. But it's like, when it really gets down to it, just because a child is going to another state, sometimes we feel like it's like all things are just, the standard is different. And we just want to remember it shouldn't be any different. If they were in Washington, that person would have a background check. They would have someone go out and see the home environment. They would have all these things. But sometimes we see that. And so just remembering that piece is that emergency here in Washington doesn't mean that, you know, that a child should have less when we send them to another state just because they're out of state. So we just like to keep that kind of frame, because we hear that all the time. I'm like, you know, we just process the paperwork and try to get it going to the other state. But when it comes through, we're like, uh-oh, you know, do they know anything? Or conversations with our fellow state when we're in violation and we're trying to get them to assist us in bringing it into compliance. Will they consider it? And they are asking us those questions. Who's making this place? Why would you send a child there without this? And now you're making it our emergency. So it makes it really hard when we have those conversations to get the other state to engage sometimes when we think about it like that. Is this a different standard, or is it the same standard that we would expect to see if we were making a placement here in Washington?
I'm going to read a couple of the chat questions. Somebody asked, why does the name not remain the case name of the mother versus the oldest child? So the clarification is the case name remains whatever the case name is. Our assignments are in our unit go by the oldest child's last name. So for example, if a family had 2 different names of children, if there was a B and a K, for example, but the oldest child was a B, Dolores would have that case. So it's just how our state and some of the other states assign their ICPC cases. So it's assigned to a certain staff. And then somebody asked, can you have several ICPC, several ICPC requests? Generally, states will accept at least 2. We try to ask workers to have a family team decision-making meeting or do a little bit of legwork as far as who has criminal history, who can keep children long-term, who's the best resource to keep these children together, or if children do have to be put in 2 different homes, you know, for large sibling groups or any other family decisions, we can do that. If all family members want to do it, or courts or people are really insistent, the workers can email our unit and we can ask the other state. Of course, if it's going to, you know, multiple states, but you know, the thing is if you get 4 approvals back, how are you going to make that decision, right? Like, so we sometimes let people know, like, you know, do some of that upfront work so that you can see what might be appropriate, or have families kind of work with you to make some of those decisions as well. But workers can contact our office and we can follow up with the other state and find out once we have more information on the cases.
To add to that piece, the area that if, you know, it's to 2 different states is not as, you know, that's a lot easier sometimes. We still want workers in the habit of screening families, because it's a lot of time and work, and we want to make sure that it's not just, like you say, we're sending to 7 different states. You know, where the challenge really comes is when we receive 2 or 3 requests for I'm trying to think, Bend, Oregon, like, you know, same thing, 3 requests for the Stevenson's office, where someone's going to say, whoa, can someone screen these or prioritize these just because of the resources? So that's where we see more of states pushing back, is if we're trying to send, you know, states have sent 6 ICPC, and we're like, can you guys, we got to narrow it down. It's unrealistic that you would say yes to all of these, you know. So again, ask our office, we can help with that, but usually to 2 states may not be a thing. It's when you're talking about, you know, 2 or 3 to the same state, and sometimes even the same town, where we will definitely get pushback from the other state. But ultimately it is, you know, the other state has a say in it when we submit.
Other questions?
One other little tip I wanted to add, Shannon, when we were talking about approvals, right? Like we always hear, the ICPC's approved. We've heard it's approved. Stop, pause, visit the home study slide again about a lot of conditional approvals. You know, those examples that have been in the news is where someone doesn't pay attention and see that Washington needs to check on the criminal history. Right? We have to remember that approval in another state, you may read that and it may not be acceptable to you. Right? Approval in, you know, states just have very different standards. And I just wanted to point that out because we hear that all the time. Has it reached your office ready to place the kids? The home's, you know, it's approved. We heard it was approved. And refer back. There could be conditions we have to meet. Hey, this is a great place, but you're going to have to travel 120 miles to get speech therapy for that age of a baby, you know, youngster. You know, things like that. Like, So just remember that all approvals are not equal is what I wanted to, and all denials aren't either. But I just wanted to put that out there because we get that a lot. And we're always like, they haven't even read the home study or they got a draft. But you really want to see the final thing, and you want to look to see how that child's gonna, that's how that transition's gonna go, and can that caregiver really meet the child's needs is what we talk about definitely with the workers. You as well know the children. So does this look like a good fit, even though they're approved?
Yeah, that's a good reminder. I've had workers call me and after reading the homestay and saying, this is not the person I have been talking to for the past 4 months on the phone. I don't know, like, just the information, the home study is so different, or, different things were minimized or left out. And then you really workers have to staff and see if there's, if you're choosing between two different placement options or looking for permanency, if that's going to be the best placement for that child.
I have a question. As far as services go, I've noticed that here in Washington, we really work hard to plug the kids in early to services, speech therapy and OT and all of that. And other areas of the country are not as focused on that and don't have the services available. So a couple of different cases that we're dealing with right now is to areas of the country that don't have that level of service, but they would be relative placements. And so, how much is weighed? They're in temporary place here and in good, foster homes. However, a relative could be a long-term placement, but the services aren't available that are available here. And we're not going to change the culture in these other locations. So I'm just wondering how all of that plays out.
That's a excellent question, Sarah. And I think that there's a couple things. What's not provided, I obviously asking and trying to drill down and make sure, right, that there's not something beyond what's just available from the coupon, their medical card, what's available, that if there's something additional, should we look at that if there's the ability to contract, right? Like, so maybe their service office that's not necessarily in their array of, I don't know, let's just use speech therapy. Maybe their birth to 3 here, that's part of that, right? Like, or the school districts help set up some of those services really early, right? In Washington. There's other states that don't offer that, but there may be a speech therapist available in the community. It will take time to get that contracted, but that might be an option to look and say, are there providers that aren't part of their normal service array just under the medical card? But those are the things that are really important to be asking and planning ahead, because those are the situations where, like I said, this question is a great question, because the difference of getting a contract and everything in place is, 2 months, and the child could move there and be successful and thrive, versus we send the child now and hope we get it figured out, right? Like, so planning or asking those questions and seeing, I assume those are probably available in the community, but they may not just be part of that child welfare's array of normal services, right, that they would offer. So I would ask a little bit more about that. Like unfortunately, it's like Google is our friend in the sense of people will ask, and if we don't know, sometimes we'll even just, what county is it in Texas, whatever, wherever the child is, and look up for speech pathologists, and then you kind of find out what can happen. I think it's a great question, because although medical, Medicaid, is, I think, is that the right one? Medicaid, is that what Medicaid, Medicare? Okay, Medicaid, you know what I'm trying to say. It's a federal program, but it's administered by each state. So we run into this in Oregon. Oregon doesn't cover glasses. So we know that all the kids that go to Oregon, our coupon covers that. Here, they at least get one pair, we know, so it's just some of those things we just have to work around. Just tell the worker, with Oregon, we know, hey, you're gonna have to pay for it. We're gonna have to, you're gonna have to figure out how to pay for it. That's normal. But you're right. When we send kids farther away, and definitely we don't have the relationship with all those states as tightly as we do with like Oregon or Idaho, where we learn the system a lot. We can kind of help you along a lot better with those states.
I think that the records would
like, why isn't the child getting this? And it's just, you're right. It's just not available. They just don't do that level of care, of support for children. It's, and we're working really hard. The workers have to work extra hard to do that. It's very challenging. I will tell you that. It's very challenging to get contracts in place.
So it's contracts, so it would be Washington paying for like a private speech therapist down there. Okay. Thank you.
Mm-hmm.
That brought up another scenario that we've recently had a good reminder on services and contracting. Part of that homestay is good for 6 months, is that gives us a little bit of time to look at those contracts and try to get those in place. The worst thing we can do for a child is have them in therapeutic foster care here and plop them with a relative somewhere else, because they have all these supports in the home that they're in here. And then, we put them in another state with nothing. So when we talk about being planful, when we talk about not burning out relatives, when we talk about, relatives not, the real life things that happen, relatives losing jobs because they have to stay home with a child because there's not services there, some of that contracting or legwork, doing it before so that it can be successful and a long-term placement and children can get permanency, versus having a child return quickly because we just weren't planful, is, sometimes really difficult for us to see when we've, made different suggestions for the workers and those things as well. So, that level of care should, if we know that it's something here that's contracted, we need to start contracting in those other states.
Yes, and that's a great, I think, especially because of the things we talked about, staff turnover. Sometimes you may be in the child's life longer than the worker, right? If there's a lot of changes, does that happen? Where you're okay? I thought so. So my point to that is, we cannot stress the lens of looking at that home study and looking at how they describe how that relative, can they manage this child? What is your experience? What is your experience, the care and the structure, not structure, sometimes, because we have the other side too rigid, not a rigid enough, those types of things for this child to really be successful, because that's what we see. And it's really hard. Like, these are the things that is not part of our training. It's just sharing that the most often thing we see of children coming right back after everyone's been pushing and trying to get a home study with this relative, they can handle, and then the child goes and they're back in a very short period of time. One, it's the services, the supports, but also no one is looking at really what type of caregiver is this child successful with here in Washington. Maybe the relative needs a little course on trauma-informed care. That would help us in all the we track disruptions. And unfortunately, that would be a big thing that would be helpful. And that is something that could be recommended, like, this child's been in this type of placement here, there, that, hey, why don't we recommend, as much as the caregiver says they can handle it and they're ready, here's what we know about, child A and child B. So that's just another thing in your role that I think would be really helpful and have the most impact, is looking at that caregiver and knowing the child. What are we seeing?
So Maya and Shannon, that might be a good thing to hint at your new caregiver unit money that you guys just got with the state about how we could do some of those caregiver trauma-informed caregiver trainings for folks in other states before we send those out. Just putting a little bug in your ear about that. And I just wanted to clarify quickly too, when you said that the child needs to be found dependent or have a petition filed before we can start the ICPC process. They need to be found dependent. Okay.
Yes.
Thank you.
Yes, and if there's additional questions about that, Shannon listed our policy. And so it would also be in there in the slides. Like you needed to go back and look at what policy number it lists. It will say dependent, you know, that it requires the child to be dependent in our policy.
I want to thank both Shannon and Maya for making this presentation and making yourself available for questions. For all you all, I will be posting this hopefully within the next day or two, and so that you can share it with your staff and your volunteers as you wish. So thanks everyone, and thank you again, Shannon and Maya.
You're welcome. Thank you for having us.
Thank you, you guys. Have a
Thanks,
great
ladies.
day.